All right, welcome everybody. Thank you very much for your patience. My name's Peter Phillips, and I'm the director of the ADR Skills program here at New York Law School. This is the first of our series of CLE programs for the 2025-26 school year. And we're starting it off as we have last year as well with a program on collective bargaining, dispute resolution, in particular, arbitration under a collective bargaining program. We're joined by Rosemary Townley and Howard Edelman, whose generosity to the school has made this series of programs possible, and we're very grateful to them and hope that as we move along tonight, we might be able to hear from their wisdom as well. But the main course has to do with the Metropolitan Transit Authority. And for that, we are very fortunate to have Baimusa Kamara, who is not only an accomplished attorney, but I'm very proud to say a graduate of New York Law School. And very, very happy that he has agreed to join us. Welcome, Baimusa. Good to see you.
Good to see you, Professor Phillips. Thank you.
Yeah, and unfortunately, we understand that Rasheeda Baksh is under the weather and not able to be with us. But at the 11th hour, good old Arthur Schwartz came by, and
Yes.
I'm so grateful to you, Mr. Schwartz. I really appreciate your coming.
You're welcome. And I
Uh,
get to present the union sign instead of two men.
well, exactly right.
Oh,
And
yes.
I don't know who else could be better at it. For those who may not, recognize and genuflect at the name, Arthur Schwartz is one of the really prominent labor lawyers in New York City and represents 32BJ and the Transit Workers Union and all kinds of other wonderful labor organizations. And I'm very, very, very grateful that you could join us, Arthur.
You're welcome.
I want to remind everybody of the way we usually handle these things. So I'd be grateful if everybody muted their mic and allow for speakers to have uncontested control of the airwaves. We are recording this for posting on the school website. If people are interested in posing questions to the speakers, I wonder if you could go ahead and use the chat field. I'll monitor the chat field, and periodically I'll loft those questions in or observations that you might make. Also, you have all received two now notices, one yesterday and one today, that include links for CLE credit and for an evaluation form of the program. For online CLE, the state of New York requires periodic attestation that you're still among us. And so in about 20 minutes, I will give a code word. And in about 20 minutes after that, I'll give a second code word. And at the end of the program, I'll give a final one. Please just make note of those words. And then when we're finished, make that, click that form in that email, and you'll be able to put the three code words in there, submit it, and we'll arrange for your CLE credit. That said, Baimusa,
Yes.
please hand it over to you, and thank you.
So thank you, Professor Phillips, Arbitrator Edelman, Arbitrator Townley, for inviting me to this event. And thank you also to everyone participating and viewing us tonight. Honestly, this is a high honor for me, not only because, I'm giving this talk at New York Law School where I proudly graduated so many years ago. I'm not going to tell you when, but also because the invitation came from two people that I truly, truly respect and admire. Thank you, Howard, and thank you, Rosemary. Just briefly, when I was a student at New York Law School, Professor Ross Sandler, and I'm sure most of you probably know him, certainly a legend at New York Law School. used to host what we used to call the New York Law Series, which is similar to what we're having here today. Those series were very informative on municipal governance generally. There was this one topic on a series that, I wanted to hear about, and I was looking forward to it, and attended it. The speaker, who was well credentialed, took the podium, spoke for 45 minutes to an hour. Absolutely did not address the topic. It was off topic. And in the words of Shakespeare, it was sound and fury signifying absolutely nothing. So, believing as I do in equal opportunity, I plan on doing to you guys today what that speaker did to me so many years ago. So, buckle up. I'm just kidding. Um, but I am so very honored to also have Arthur Schwartz join me in this discussion today. Arthur, as Professor Phillips has already said, is a well known lawyer in New York City labor circles and across the country. He has served as general counsel for many labor organizations, including one of the largest in New York City. He also hosts a show on WBAI, so check him out sometimes. True story about Arthur and myself. We started off as arch adversaries back in 2013. We fought about everything as we represented our respective clients. We agreed on nothing. We fight about everything. But over time, Arthur and I kept talking and we spoke a lot. And we learned that with communication, everything is possible. And today, Arthur is not just a good friend, but I consider him a brother, as you can see the resemblance between the two of us. So I tell you
A
this,
brother from another mother.
that is correct. So I tell you this for no other reason but to emphasize the point that in workplace dispute resolutions, generally, like most other things in life, talking with each other goes a long way to getting things done. I guess Arthur and I realized that neither of us wants gridlock. So if we want to get things done, we got to talk. So remember this, whatever you do in communication, things are possible. So I look forward to a spirited discussion here tonight. And thank you, Arthur, for giving the labor perspective. Thank you.
So, one of the interesting things I've been doing that I have to say first, I think I first appeared in front of Howard. It had to be around 87, 88, 89, somewhere around there, with the utility workers union, right? One of the unions you've done arbitrations for over the years. So we go back a long time. And I'm a 1978 graduate of Hofstra Law School. I was in their fourth graduating class. And so one of the interesting things about I represented TW since 2001. There was a period of time I was general counsel. There was a time when I had the entire staff of lawyers that did disciplinary arbitrations. I did all the contract arbitrations and pretty much have done them continuously since 2001. In our union, we have a panel of arbitrators that do disciplines, and we've had two contract chairmen, or I think whatever we call it, impartial chairmen, since 2001, just Richard Edelman and now Howard Edelman, which is shows a fair amount of consistency in the relationship. I am a big fan, even though I go to court all the time and I sue the transit authority all the time. I'm a big fan of resolving contractual issues in arbitration. I often will convince workers who have issues that there is a way to resolve it without going to court. And if you have a healthy, frequently meeting arbitration system, in my opinion, and that includes disciplines as well, that the members feel, the people we represent feel like we're representing them. I think in the Transport Workers Union, fortunately for a number of younger arbitrators, maybe some older arbitrators, we have calendars going back to when I started, we pushed it so that we had arbitration calendars every day, every single day, and we would have. There was a time when the transit would schedule 15 cases in a day, but we got it down to 5 or 6. But it's a very healthy, moving process, and if somebody gets disciplined and served with papers, they get a hearing really rapidly, and they feel like they're being taken care of. And one of the things that I hear a lot as a lawyer that whose name is out there is people calling me to complain, oh, I got fired a year ago and I haven't had an arbitration. And it makes people hate their union, and it makes people who are in the workplace believe that they don't really have any rights. So if you have a healthy arbitration system, both for discipline and contract grievances, it really it builds employee morale. It's very important, both, for both sides, because management is always coming to the union and saying, um, how do we get more people to come to work? How do we get more people to stop taking all those sick days? How do we get people to be more gung-ho? And one of the things we always say to them is we have to make people feel like they're being heard. And so it's important both for us as a union and management, who needs the employees to feel like they're not, uh, that they have ways of challenging things that they think are wrong, um, to have and arbitrators who they have to feel like the arbitrators are listening to them, the union is paying attention to them, management isn't trying to block um, resolution of their problems, and it can work out really well. And I think that I think one of the ways that I measure, as opposed to some other public employee unions that I don't represent anymore, but I have in the past, um, TW has about a 99% membership participation. Like only 1% of people have exercised their rights to not, send in union dues. It's probably the highest number of um, full participation of any public employee union in New York City. And I think this is a big part of it. So and BK and I have worked together on and off now for a dozen years. I thought it was even longer, but uh,
It's actually longer, Arthur. We started in 2001, but as adversaries in 2013 was when we started going.
And um, when management works with the union to get a system working that may put a lot of pressure on both sides, a lot of work. Howard probably gets these calendars that he looks at it, it'll have like 9 cases on for one day. Um, but if you do it and you prepare for them and you push them and you get it done, people feel in among the membership that they're being paid attention to.
I wonder, Baimusa, if I may, could you please lay the groundwork for those in the group that are not familiar, how the arbitration scheme works in your contract, and in particular, the difference between contract arbitration, discipline arbitration?
So, just by way of background, collective bargaining, as most people here know, at least in New York State, has its origins under Civil Service Laws, Article 14, otherwise known as the Taylor Law of New York State. It requires that public employers bargain, among other things, the terms and conditions of work, salaries, and the likes. On the discipline side, that's also a part of the requirement in collective bargaining for most of the employees in the transit authority who are civil servants. By the way, just to step back a little bit, many people know our agency as New York City Transit. There's a statutory subsidiary. It's called the Manhattan and Bronx Surface Transit Operating Authority. These are the buses in Upper Manhattan and in the Bronx. It's a separate company. The employees that work for MapStore by statute are not New York City Transit employees. So those employees in MapStore don't have an underlying civil service title because it's not a civil service agency per se. Transit Authority employees are civil servants. However, through collective bargaining, discipline, the process by which we adjudicate disciplines is laid out. In the Transit Authority, just using Arthur's example for the TWU, we have a three-step process that ends in arbitration. Normally, where there is no CBA, for civil servants, the process is through Section 75 of the Civil Service Law. And most people go to oath, which I'm sure some people know, the Office of Administrative Trials and Hearings in New York City. Civil Service Law Section 76, however, permits those due process rights under Section 75 to be bargained or collectively bargained and governed by a CBA. So for transit authority employees and MAPSOR employees, the grievance processes are laid out in a CBA. Um, there is a step one for our employees and where they initially get to tell their side of the story and management tells their side of the story. If there's no resolution, they have a right to appeal to a step two. And step two, we have hearing officers that all work here in the Office of Labor Relations who are independent. They get to hear from both sides, the labor side and management side. If there is no resolution, the case goes to arbitration. And then I see that some of the people who had previously served in our panel are part of the audience here today. I'm sure they get to speak a little bit or maybe ask questions about some of the things that we do. But that's basically our process. I think your question was to lay out the process that we have here, Professor Phillips. Forgive me.
Yeah, that's great. I just want to make sure everybody is on first base before we move on. Is there any formal structure for a dispute resolution prior to formal arbitration? In other words, are there a conciliation or mediation effort?
There isn't. There isn't. I know some unions will have a second, a step between the last grievance hearing and arbitration to try to resolve things. But I think I think that the procedure that we follow, the disciplinary arbitrations tend to be more formal. Um, you know, there were witnesses to the facts and sworn testimony, etc., before the arbitrators. In the contract situation, and both Richard and Howard have functioned this way, we have freewheeling discussions. So it's sort of like it's like mediation before we start putting on documents, and it really does work. Uh, Howard will say, okay, what's this case about? And then in the contract side, the union has the burden, so we sort of control the calendar and go first. And we'll explain it, and BK will, or Rasheeda will argue with me, and very often we have a discussion which is more in the realm of mediation, and Howard might suggest something in the middle, and then if we don't resolve it, then we put whatever witnesses on that we need to put on, and it works in a pretty expedited way. So in that side, on the discipline side, I think the arbitrators and some of Randy's been an arbitrator, I see on the screen. Um, uh, will sometimes try to mediate before, like I think most arbitrators do, right? After they hear the employer's case. Um, and it's both important because it saves money, and also because they may have 5 or 6 other cases on the calendar that they want to get through before the end of the day. One of the good things that happens with civil service employees, so we negotiated back in the 80s not to use the civil service system, the Section 75. And in a lot of unions, you can have an alternative. In transit, that you can't go to oath or any other agency. You just go to arbitration. And
Well, say for a few titles or others.
one of the good things is is discipline can't be imposed until after arbitration. So it puts, as opposed to people in the private sector where someone might be out of work for a long time before they go to a hearing. Um, Everybody's motivated to get it done.
Baimusa, could you tell me, give me an example of the kind of issue that's, commonly brought up in contract arbitration and the kind of issue that's commonly brought up in discipline, just so everybody understands the distinction?
So, just to lay out what we consider to be a contract grievance. It's a claim that management has misapplied or is being non-compliant with a provision of the collective bargaining agreement or a written rule or policy instruction. For our employees, they get to do what we call a pick. That's when they select their work assignment, their regular days off, and sometimes their vacation vacations. Um, the most frequent contract interpretation grievances that we get involve picks, where employees would, for example, claim that seniority is violated in the way that the pick is put together, or that management is reducing the number of jobs that they normally would put on the pick, or that there are no assignments that are included in the pick. There were no prior discussions between the union and management. So the frequent contract interpretation grievances all surround picks. On the discipline, geez, we have interesting employees, and I just want to add the caveat that my views are solely mine, not the MTA's on this. But um, discipline mostly surrounds time and attendance. For a large agency charged with moving people from point A to point B, the public expects the public expects a train to get to where it needs to be and a bus to get to that stop. It doesn't matter that bus operator X is not there today, they just want the bus. And some of our employees, the vast majority of our employees are good employees. They come to work, they do what they need to do. But there are a few that just, for whatever reason, if the weather is nice, they don't want to come to work, they're not going to come to work. They're just not going to show up. And if there's a major sporting event, they've gone to the Super Bowl the night before, they will not show up to work the next day. So, discipline cases, the vast majority of discipline cases would usually surround time and attendance.
And does that jive with your assessment, Arthur?
I mean, a lot of disciplines are time and attendance. I don't know if all the arbitrations are in contract are pick related. It's a pretty wide variety, and a lot of times we a lot of them have to do. We have this interesting, we have this crazy contract. It's 400 pages long. Uh,
More,
it's it the Transport Workers Union was an amalgam of about a bunch of craft groups when Mike Quill put it together back in the 1950s, and um, and each has its own contract. Track workers have a contract, and electrical workers have a contract, and train operators have a section, and conductors have a section. And it's not always the same. They're not always the same. They have different procedures and different vacations and different, there's a lot of differences, and there's some parts that are similar.
Well,
Um,
if I may, why should that be, Arthur? Why is it because the nature of the job needs to be more and less flexible, or
Because you're talking about 36,000 people who do very different jobs. A bus driver can't be compared to a track worker.
different working conditions.
So the common things are vacations, that's just, vacation, sick leave, uh, the everybody gets a different pay rate, right? Their job pick procedures are all different. Um, but we also have this thing that um, John Zuccotti, who was the first. No, Ted Keel was the first impartial. We haven't had a lot. Was the first impartial chair, and then John Zuccotti. It was the second one for like, I don't know, 10, 12 years. And he, and there was a point where there was a negotiation dispute that was resolved in arbitration, and he created this standard that allowed people to litigate past practice for something that wasn't discussed in the contract, and if it is fundamental to the relationship between the parties. So a lot of what Howard hears as our contract interpretation person is this practice is fundamental to the relationship between the parties, and here's what it is, and we have a lot of cases that revolve around that. Uh, so it gets to be a pretty heady that side of it. In the discipline side, I mean most of it. When I started, we had 3,000 disciplines scheduled in the first year. I don't think we have anywhere near that now. There's been a better relationship between the union and management have worked out a better relationship, so that doesn't happen. But there's still probably 1,000 scheduled a year, and a lot of them are, t um, people with attendance issues. Um,
Does the designated arbitrator hear every discipline case?
no,
No,
no, no. So there's a panel. I think we have 9 or 10 different arbitrators.
it's supposed to be 14. We're currently
Right.
down
Okay.
a number.
And with
And
respect to contract interpretation, does the same arbitrator hear all of those claims?
yes,
For the TWU, yes. We have different bargaining units in the authority. The SSSA, for example, has a contract arbitrator that will also hear discipline cases. We also have the TSO, it's the same pattern. We have ATU 1056, ATU 726, same pattern where the discipline arbitrator will sometimes hear contract interpretations. For the TWU exclusively, we have um, a contract arbitrator. Presently, it's Howard Edelman. Arthur mentioned past practice, and I know that this is where sometimes I get myself in trouble insofar as past practice is concerned. Whereas Zuccotti talked about a practice being a cause of action where it's fundamental to the relationship of the parties. Sometime in the 1990s, an author negotiated this contract. He's more familiar with the contract than I am. We have what we call the zipper clause. The zipper clause is very clear. It states with obvious clarity that things that are not included in the CBA cannot be considered for practice. And it goes on to talk about what a past practice is. It's just evidentiary consideration. So, in my humble opinion, and this is where Arthur and I often butt heads, a past practice is just an evidentiary consideration. That's what the parties wrote in the CBA. It's not an independent cause of action that could be litigated. But yet, Arthur continues to bring the past practice claims. And
Yeah. All right, I'd like to pursue that in just a sec, but first let me offer the first code word for CLE credit, and that word is transport, TRANSPORT. Transport is the first code word. And outside of a labor context, Baimusa, the arbitrator is usually designated as the person who determines whether a claim is arbitrable. Is that still true? If Howard Edelman is the designated arbitrator, is it he who decides whether a past practice is in fact arbitrable or not?
yes. And the beauty in having Howard is that his vast experience, and he knows the parties.
he's buttering you up, Howard.
You don't have to say that because he already knows that's what I'm doing. He knows the parties and he knows when a grievance is arbitrable. I mean, as much as sometimes I would argue that that is not arbitrable, he has seen this stuff. There's nothing new that we bring in front of him that he hasn't seen. So arguments we raise as advocates because we must. But I also know that he's seen this stuff. He knows when it's arbitrable, when it's not.
And is the designated arbitrator uh, named for the term of the contract, for the term of the CBA?
That he isn't. It's an interesting question because in it's not the person is not named. The 2002 contract, which was the first one that I helped negotiate, we did have Richard Edelman in there, but it didn't get somehow that didn't get repeated, at some point the authority wanted to get rid of Richard, and one of the questions was whether they had the right to do that unilaterally. Was it something we agreed on? And uh, so we do have, none of the arbitrators are named in the contract, including Howard. I mean, if we, um, not sure what mechanism is. We do get rid of disciplinary arbitrators. There is when I first started with an entirely new group got elected in 2001. Roger Toussaint was the president. He fired every disciplinary arbitrator, uh, and we went up in court over whether he could do that. And ultimately, over the years, we came around to this agreement on having a number, and both sides could, if they couldn't terminate someone unless till the parties agreed on a replacement. But it got pretty Wild West for a while, and then now it's a little less so.
Well,
Yeah.
is that by virtue of a side agreement that the arbitrators are designated, not in the CBA itself?
Yeah,
No,
it's side agreement, yes.
yeah, well, the agreement that Arthur cited named Richard Edelman as the contract arbitrator for the term of that contract. And the argument that we presented was that that contract had expired. So, using landlord-tenant parlance, he is more or less a month-to-month tenant at that point. So he was no longer the contract arbitrator once the term expired. But going back to firing disciplined arbitrators, I'm not a huge fan of that. I think for the stability and integrity of the process, we ought not to be firing arbitrators all the time. It just doesn't work for me. So a way to get around that was to say that both parties would have to sign off on a letter when somebody's being fired. And of course, I think the union, forgive me, Arthur, has used this to say, hey, we're going to fire somebody. You got to sign off on that letter. So we agreed to it. Reluctantly, we would sign off, even though it's them that's doing the firing.
By firing, you're talking about firing
Terminating an arbitrator.
Yeah, yeah.
I'm not a fan of it. I just don't think that it creates instability.
I have a sense, and I'm not familiar with the CBA. I have a sense that the contract arbitrator is on a longer term, and that the virtue of consistency is a lot more pronounced in contract determinations than it is in discipline. Am I right?
You know what? I think we like to have long-term discipline arbitrators too, because you want to have consistency, and we have so many cases. If we had people all over the place, it would be really difficult to know people to know what their rights are. So it's really helpful that there are some people who have been around, for 20 years, in the discipline side, and who can look back at past cases and past practice. And I think the consistency is very important, as opposed to, other unions I represent that might have 4 or 5 arbitrations a year with 4 or 5 different arbitrators, and it's really hard to know exactly what the rule is. But here, here pretty much people follow precedent.
If I can interject just for a second, as the contract arbitrator, I don't hear discipline cases.
Yes.
Those are for the panel disciplinary arbitrators. And even though I've been around a long time, and Dick was around a long time before me, and of course Zuccotti and others, I serve at the pleasure of the parties. I mean, tomorrow, Arthur and BK could say, "So, it's been nice, been swell, Howard, we'll see you." But that's a constant, and that's fine. The parties control the arbitrator, control in the sense the control the selection of the arbitrator, and that's the way it should be.
How many years have you been a contract interpreter? Arbitrator for the MTA, Howard?
How long?
Yeah,
I think since 2010.
2014.
12 years, just
With the
about
TWU.
2013,
Sure.
just about at the end of 2013, so just about 12 years.
and do you in a typical are there issues that even though they've been decided, nevertheless come up again for reinterpretation, looking for a different outcome?
Oh,
Yes, by Mr. Schwartz.
the
He's
parties
always trying to
Don't
unsettle
agree.
issues.
they never take no for an answer. But and obviously, to be a little more serious, when a similar issue arises, the party who's advancing that their position is going to say, "Well, it's different in this way. The facts are different, etc." So you're going to get a lot of those arguments. But issues do repeat themselves, and I would say in at least 90% of the cases, either Arthur or BK or both are citing prior decisions. Sometimes mine, sometimes Dick Edelman's, and sometimes other arbitrators.
So my view about contract interpretation, and my staff, I see they logged on and they've heard me say this many a times. When management wins a contract interpretation grievance, in my humble opinion, it just means that we're keeping the integrity of the CBA, what the parties intended it to be. I think that when the union wins, and Arthur may disagree with me on this, they would have succeeded ever so slightly in changing what the parties intended the CBA to be. So a win for me is not really a win. I just see it as keeping what the parties intended the agreement to be. That's why the grievances are mostly filed by the union. I think 99.99999% of the grievances are filed by the union because I think they try to change the CBA ever so slightly from what the parties intended it to be.
We have an interesting inquiry from somebody who is following us from, who is a German practitioner, and they ask, are there very many instances, or indeed is it procedurally possible to seek judicial vacation or annulment of arbitral awards once they've been issued under Articles, what, it would be 75.
I'd
It
say
happens all the time.
I'd say transit files 5 or 6 of them a year. And my first 4 years when I was general counsel, I was up at the Court of Appeals on 4 times on Article 75s with transit. And they continue to be filed, and sometimes they're granted, and sometimes they're not granted, and they can work their way up the court system. And I've just briefed our office has just filed briefs on 2 with transit. We moved to enforce an arbitration. They moved to vacate it, and then there was another one where they moved to vacate it that we're actively litigating. There's a third one. We have a pretty active Article 75 exchange.
Yeah, and in fairness to Arthur, that's a recent phenomenon.
They usually discipline, so very rarely contract.
That's correct. I would say that 99% of the Article 75s that we bring are discipline related. Rarely do we bring a challenge to a contract interpretation award. Keep in mind that in New York State, under 7511, there are 4 grounds to bring an Article 75. Either the arbitrator exceeded his or her authority, or the arbitrator was biased or violates public policy, or the award is irrational. And all too often, we have found that in some of the cases, particularly pertaining to drug testing, an arbitrator would have exceeded his or her authority insofar as overruling what the federal regulation says. Most of the cases that we've challenged in recent times, and I think that's what Arthur is briefing right now, all pertains to drug cases.
Oh, drug cases. Yeah.
No, we have ones involving sexual assault. It's usually some you know some issue that's very often controversial, right? And whether it violates the first department, I guess about 10 years ago, vacated an award that Richard Edelman did, which said that someone couldn't be brought up on charges who was on the union payroll. Um, and then, and it involved a sexual harassment case claim brought by a female supervisor. And then it went back to arbitration. Um, and the court basically said it could be arbitrated, but they couldn't implement it while the person was on the union payroll. So then we at the arbitration, it was Steve O'Byrne. Steve O'Byrne's the guy that's been there for 25 years. He's a glutton for punishment, and so Steve came down with a 10-day suspension, and the transit went back up again, and the first department again vacated it and said that his decision wasn't consistent with public policy and sent it back down. And it never went back. Never went up to the Court of Appeals because the guy retired.
No, the parties resolved that. Keep in mind that, sexual harassment is it's a public policy that as a public employer, it's not something that we can countenance. In that case, we had an employee who was a union official that was accused of engaging in very egregious conduct. And the contract arbitrator said that, we just couldn't do anything while he is on union paid release. And we disagree with that concept because this is our employee and we have female employees that work here. It's not something that we're going to tolerate. Certainly not something that I would tolerate. And so when the matter came down and the arbitrator issued a 10-day suspension on somebody who engaged in conduct that's unbelievable to me, there's no way that as an agency we could just say that's fine. It just isn't fine. And another case recently, a bus operator who assaulted his wife. His wife is also a bus operator, operating a bus. The husband got on the bus, also in uniform, while this lady was operating the bus. He started hitting her on the head, and she did her very best to control the bus, brought the bus to a stop, and got off the bus. And this guy just pummeled her, knocked her out cold on the sidewalk. And the discipline arbitrator says, well, he spent the weekend in jail and I feel bad for him, so I'm going to put him back to work. There's no way that that's going to be fine with me. So we moved to vacate that award. The court agreed with us. The matter came back down and the employee's been fired.
I'd like to pursue that. This is probably an age-old question, but when in arbitration there is alleged conduct that is consistent with criminal conduct, what is the relationship between the criminal law and the law of the workplace as it's in the state?
So in the contract, it says that if the violation the arbitrator finds is a felony, he can't put the person back. If the arbitrator finds something that's a misdemeanor, I mean, I'm paraphrasing, that he can take various factors and it lists the factors into consideration and put the person and reinstate the person. Some of it has to do with length of employment, et cetera, et cetera. And so in the case BK just talked about, that's what the arbitrator did because the guy was ultimately, and in the court system, he took a plea to a misdemeanor. So and those do become hot button issues.
Exactly, because I mean, if I understand right, this guy is being indicted criminally by the state or by the city at the same time that there is a workplace discipline arbitration going on.
We put them in abeyance. Those cases get put in abeyance until the criminal process is
until the criminal case is done. So we generally discipline employees when they engage in off-the-job misconduct. They get arrested. Unfortunately for us, for a large agency with 40,000 plus employees, some of our employees engage in conduct that is just unbelievable. And so we take action against them because they put the agency in a bad light. I know there have been in recent times 1 or 2 cases that says that, well, you have to consider nexus to the job, which I don't believe the contract says, but this is just me talking from a management perspective. Arthur disagrees with that, I'm sure. I just think that as a public employee, when you get arrested, for example, let's just say domestic violence, beat up your significant other of the job and you get arrested for that as a public employee, it's a big deal to me. It just is. And so disciplinary action is going to be brought. And this is not to say that I just willy-nilly bring disciplinary action against our employees. No, I don't do that at all. Because I think we invest a lot of our employees, and to try to take somebody's job is a big deal because you're not getting a return on your employment. But at some point, as a public employer, I think there ought to be, for lack of a better word, a code that you stand for, something that you stand for, your moral principle as a public employer.
Just to spell it out for me then, Baimusa. An incident occurs that results in criminal charges and also results in disciplinary arbitration. Does that employee remain on the job while the criminal action plays out and before the workplace arbitration can take place?
Well, they technically they can only suspend someone for 30 days without a hearing. We have a case we have a case in the Howard decided what 30 days means, which is actually that's an Article 75 that the authority brought that's up in the appellate division. And um, but they can only do 30 days. So at their 30-day point, then the employee has a choice. They can move forward. Um, the transit might not put them back to work, but they're on the payroll. And but they have Fifth Amendment issues that, they might be asked questions that could incriminate them. Usually their lawyers will tell them not to. Or they can put it in abeyance, which means they're waiving all back wages. We have had a couple of situations with somebody moved forward, um, even though he'd been arrested for something where the situation was somebody picked up a woman. He thought she was interested in him, but she was a prostitute and she was looking for money. And when they finished, she said, "Where's my money?" And he said, "I thought you were in love with me." And and she called the police for rape, and he got arrested, and ultimately the cops couldn't find the complainant, and so he said, "I'm going forward." And transit, they couldn't produce that he didn't get indicted, he didn't get he had been arraigned and charged, but and transit couldn't go forward because the police didn't have a witness and they didn't have a reliable source, and he went back. So, but generally, um, they take the abeyance, I would say, in my experience.
Yes,
99% of the time, and then everybody just waits for the resolution of the criminal case.
that is
All right, let me give the second code here. The second code word is workers, WORKERS, workers. I wonder, Baimusa, do you represent the Transit Authority in contract negotiation as well? What's the term of the CBA and how frequently is it renegotiated?
so. I'm not actively involved in the collective bargaining wing in the agency. Presently, labor relations is headed by three of us. I'm in charge of the litigation aspect of it. My colleague, David Francis Kinney, very smart young man, is in charge of collective bargaining. And my other colleague, Ali Abdulrahman, is in charge of uh, uh, interfacing with the union, day-to-day labor relations. So the collective bargaining aspect, I'm not actively involved, though I do play some role, particularly in negotiating the discipline aspects.
Yeah. Arthur, do you represent the union in those negotiations?
Yeah, so I have been both in the so what happens in our negotiations is we have a central, like the central issues, wages, major changes, let's say in pregnancy leave or stuff that comes up, that's a big demand, attendance policies go by happen, retirement, health insurance, health coverage, right? That all gets negotiated. And then they have separate, since we have 17 different divisions, there's 17 different, or maybe 10 different rooms that go on with the different departments, and then they might also have one with women's issues, and we have a room with uh, with technology, and we have a room with something else, and so there's a lot of negotiations going on simultaneously. So BK and I have been in some of lately. The last time I was not in the central discussion, BK and I did some of the departments together, like rapid transit um, and car equipment, and they come out with 17 different sheets of paper with different agreements that modify their section of the contract. The contracts tend to be 3 years, tend to be. When Andrew Cuomo was governor, uh, he was the the first time that there was a new president in TW, John Samuelson. Um, in 2013, the governor was like insisting on zeros, and John wouldn't take zeros, and the contract actually went. This is one of the few unions that rarely goes beyond the deadline. Um, Most public employee unions are sometimes I represented the professional staff Congress once. We settled on a Friday, and by the time we settled, it expired. The 3 years had expired. We'd been negotiating for 2.5 years. TW tends to be, this no contract, no work history. They tend to settle within a day or two or three of when it expires. But in
Yeah.
2013, it didn't. And then in 2014, John made a deal with the devil, and he got 1% that nobody else got. So
Who's the devil, Arthur?
the devil named guy named Cuomo. And
No
he doesn't like
comment.
Cuomo. He doesn't like Cuomo anymore. And so the next contract only went 2 years. Sometimes they go, but generally they're 3 years. They try to keep it at 3 years because wage projections and wage increases are a very difficult question these days. Inflation is up, inflation is down. Money is up, money is down. So we usually go about 3 years.
It was only this morning, Arthur, that I was reading in the paper about a transit strike in London. And I've been in Paris when there's been transit strikes and the whole place just goes nuts with, some very memorable exceptions. That doesn't happen in New York.
That's not true. I was general counsel in 2005. We had a strike. It lasted
Well,
three.
it really happens in
It
New
lasted 3 days. It we needs it. There was one in 1980. There was one in 1966,
Yeah, well,
and
yeah,
there was
but
one
I'm
in
trying to
2005.
I'm trying to throw a congratulations your way, Arthur. It strikes
Thank you.
me.
And I sense that's what you were trying to do, Professor
Yeah, it
Phillips.
strikes me that, the relationship is disciplined and assertive and so on, but it generally the two of you serve New York City. Now, am I nuts about that? Is that
No, no,
not?
no, no. I don't think. Listen, each of those points. Well, the 66 strike with Mike Quill, was said, went to jail and died in jail. Was an you know was a big turning point in changing labor relations there was not good labor relations before that. Um, The 1980 strike was more a result of internal union. The board was split like 20 to 20, and somebody was on military leave, and there were 20, the dissidents had a majority, and they voted no on a contract, and John Law said, well, if you vote no, we're going on strike, and they went on strike. In 2005, Roger Toussaint was, I don't know, just had to show his militancy. I always have this famous story. The international came to the executive board meeting. It was 2:30 in a.m. and the night negotiations hadn't resulted in a contract, and the general counsel of the international president talked to the executive board and said, "Don't strike, don't strike, don't strike, don't strike." And then Roger took his top officers and me and Terry McGinnis, who was working on negotiations, and Basil Patterson, who was just such a wonderful guy. And he took us into a room to talk about what we should do. And he called on me first. What should we do, Arthur? And I'm looking around and I say, I guess we should go on strike, right? And we went out for 3 days. and it was pretty wild. But I think that since then, I think the relationship, you wouldn't see that. There's nothing that suggests that that would happen anytime again soon. But could it never happen again? I would never say that.
Well, there's never, but yeah, I don't know.
If I may just
Baimusa,
chime in.
to what do you attribute what Arthur is saying is the era of good feeling?
I think it's the good relationships that we have with the various unions that represent our employees. I mean, we view them as our business partners in moving people in this city from point A to point B. It's an awesome responsibility. I think it's a responsibility that's recognized by our labor partners as well. Um, there are some things that we simply don't agree on, but we agree to disagree. But when we go on strike or the unions take us, you know, put us on a strike mode, I think they recognize that it's not only the agency they're punishing the people of the city of New York as well. I think it's that also responsibility that often gets people to just keep talking. And it goes back to what I said earlier when we started this discussion. Communication, that open line of communication. When you talk with people, gridlock is avoided. We may not agree, but at least we hear each other and we get to where we need to go. We not get there 100% of the time, but we take the positive steps forward.
And I would say, Peter, that there's been a better choice of leadership. Since in 2010, when Samuelson came in, there was a guy named Walder.
Yes.
And there was somebody, and the new MTA chairman was, they were, both of them were just in for a fight. But something happened, and there was a new MTA chair, and there was a new Transit Authority president. And since then, the series of presidents we've had have been really good about reaching out, talking to people. I mean, I've sat with the president of the Transit Authority, not only talking about an issue that's really important, but then with personal relationships and, really treating the union officials like they're people and not just, underlings. And, and our current chair, the current president of the Transit Authority, Critchlow, he was a transit worker and his dad was a transit worker. And
Yeah.
it helps a lot.
He came up the ranks, and he's a gentleman that just simply cares about the people that work in this agency. True story. And I've told him this many a times. He and I have worked together, and I see him stop by and just engage in station agents in a conversation. How are you doing today? How's your day going? How can I make your job better? To me, sometimes, people just appreciate the respect that you give them. That station agent is going to go home and it's going to say the president of the transit authority stopped to talk to me, to ask about my family, how my family's doing, how my day is going. That builds morale. And I've told him this. I've been impressed by him every time that he's done this. So, it's just respecting your workers, which I think we do on the management side.
I think that there might be room for the two of you to volunteer for Major League Baseball in about 18 months.
Hey, Howard, you could get us a job there, right?
Now I was going to ask Rosemary about that.
I was about to ask Rosemary. You've been listening to this very, very, very calmly, Rosemary, and I know that you've had experience. As a discipline arbitrator under this contract?
A discipline arbitrator, and I believe a contract arbitrator with one or two of the unions.
Yes.
So it is not as extensive as Howard, but it's really fascinating. And again, it's
tell us about your experience and observations you had there, particularly if they are unique to this particular CBA.
Well, because I was dealing primarily with certain of the bus drivers, I was just truly amazed by the relationships that they were able to develop, first of all, among each other, and then from what I could tell from the testimony, as displayed to patrons and so forth. Yes, you do hear those crazy stories about who tries to evade a drug test and so forth. And those stories will always be there. And it's not just in this industry. It's in other industries.
Mhm.
It's just football and other venues where I've had experience, but I would really have to defer to the speakers here who have had, literally decades of experience in terms of dealing with transit, whereas mine has been much, much more limited. But it is it's so important. I mean, it's, to me, the heartbeat of the city is the MTA and the workers. Without it, nothing moves, nothing goes forward. And walking in as an arbitrator, I think you need to keep that in mind. This is a very important industry. This is not one that you just shun aside. And, you must, I think you have to respect the process, respect the contract, respect the people. Those are
Can
three takeaways I had.
Can I ask you, Rosemary, from an arbitrator's point of view, when I said, when a hearing is set in an arbitration that I do, we set aside 6 days or 7 days, and we have, evidentiary rulings and things like that. Now I'm listening to arbitrations where there are 5 or 6 of them in a day. What's that like? I mean, how can you run that process in a way that the grievant feels, as Arthur said in the very beginning, that they've been heard and that they've been respected and that the process is reliable to them?
I think it turns in large part on the underlying processes that occur before they get to arbitration and the work that the representatives, the union representatives, and the management representatives put into that process. So by the time arbitration arrives, they feel as if the case has been well laid out and that the arbitrator will hear the most salient important points of the case. I know this is true also in certain UPS disciplinary arbitrations, where you're given a calendar of 4 or 5 cases, and you're making your decision essentially from the bench. But there's been a very thorough grievance arbitration process with multiple steps, where the grievant, I believe, feels as if they've had the opportunity to be heard, and that ultimately, when arbitration does occur, everything's out there. So it's not just, one occasion for someone to hear it, but there's been at least a thorough investigation of what occurred, at least in my experience. And as I say, this would cross over to other transportation related type of industries.
Yeah.
I mean, Peter, it's also true that in these transit situations, or New York City transit particularly, it's very common for Arthur to turn to the grievant, which is often a shop steward, in addition to an individual person who's been aggrieved, and say, why don't you tell the arbitrator what happened? And the authority sometimes will object by saying you have to, not only do you have to swear him in, but he has to be subject to examination and so on. But, what really happens is the guy or gal tells a story, and then the authority goes ahead and they tell their story. And that informal process, or mostly informal process, is what lends credence to the notion that the parties hear each other, and they give these individuals an opportunity to express themselves. And it's very important. It really is. And there, frankly, credit goes to Arthur and BK.
That too, it seems to me, is a credit to both Arthur and Baimusa, the way they handle their constituencies, right?
Yeah. Well, just to say my last comment, then I should shut up. But just to say that it's not always kumbaya. Yesterday, I had a hearing with Arthur and BK, and they were going at each other pretty good, which is okay. That's life.
But I was the witness and he was cross-examining.
Arthur knows look, I can't help myself. I could be overly aggressive in cross-examination, but he knows there are no hard feelings to it.
The only thing I want to add is that after the hearing was over, I spoke to Mary, my assistant, and I said, "Show me how you can mute mute everybody at the hearing," and she did. So the union and the employer now are noticed that on occasion I won't listen to anything.
Yeah, well, it really goes to your credit. By the way, I didn't even check before. Well, let me just ask,
Can
sort of
I,
out of the,
can
yeah,
I,
go ahead.
can I just give a plug to my fantastic staff who are out there every day litigating these cases. I know some of them are tuned in, and also noticed that arbitrator Randy Lewitt, who is also on property and heard most of our discipline cases, is also on. I just wanted to give him a shout out.
Yeah, they deserve it. Well, the two of you, I think, are obviously well served by the people who you work with. Has either of you ever worked through Ray Kramer at Oath? Have you ever gotten involved in some of the dispute resolution stuff that Ray has been doing?
No. I know early on as a labor attorney, I had the great pleasure of appearing at Oath and before Judge Kramer, but I haven't been there in
Yeah, me
almost
either.
decades.
Yeah, because he's handling some stuff that like in restorative work or circle work or things that are really pretty innovative, and I wonder whether any of it has had an impact on the TWU. But no.
No, but I think that I really do think between Howard on the contract side and a lot of not all the arbitrators on the discipline side, there is an effort to resolve stuff, you know, not in a pushy way. I won't say there's an arbitrator that we use sometimes who's very pushy about resolving stuff. Um, um, he's a very good friend of Howard's, and uh, but in a respectful way, and so there is an effort to do that without having to resort to outside. We settle a lot more than we litigate.
I know we're talking about discipline arbitration generally. I just don't want to leave the impression that we do a lot of discipline. The vast majority of employees here are fantastic people. One thing that we notice is that NYPD are the men in blue, and sanitation has their own moniker, and the firefighters has theirs. But what people often don't realize is that transit employees are out there, whether it's raining, whether it's snowing. When we have a snowstorm, those trains are running the next day. Those buses are out there moving people from point A to point B. I venture to say that we probably have the best employees in all of New York State. I just want to plug MTA employees.
Well, they deserve it. They deserve it. All right. Well, the two of you have been absolutely terrific. And Howard and Rosemary, I thank you again for helping us set this program up. It means a lot, I think, to so many of what we have 60 or so people up there. And, it really matters a lot to the school. Let me give everybody the third and last code word so you can get your well-earned CLE credit. And the word is union, UNION. Union. Baimusa, thank you. Arthur, thank you, considering that what short notice you had. You're very generous. Very
No,
generous.
of course. Arthur, this is a testament to Arthur being a great litigator. He just comes in last minute and he's able to do stuff.
And you're a
And
man.
I had to tape a radio show, like it live. I had to tape it so
Oh
I could.
man. Yeah, the greater love hath no guy than
By the
some.
way, anyone that ever wants to, I'm on WBI on every Wednesday at 5 live, and it's on WBI.org or WBI FM, which is 99.5. I don't talk about work. I don't talk about work. I don't talk about being a lawyer. I don't do it as a lawyer. It's all about politics.
So what were you going to invite me to talk about?
I
He said, you
appreciate
got to come to my show. So I don't know what you were going to talk about. But, thank you, Professor Phillips. Thank you,
I
Rosemary, and thank
appreciate,
you, Howard.
yeah, I appreciate everybody's goodwill.
And forgive me, this is the first time I've called him Howard.
Okay. It only took 12 years.
Great. Thank you, everybody, for coming, and I hope we'll see you next month for our next CLE.
Thank you all.